We are presenting this series, The Supreme Court at a Tipping Point, in collaboration with the National Constitution Center. And I just briefly want to acknowledge a couple folks from the National Constitution Center who are helping us with some special programs on the Constitution this week. Tom Donnelly, Senior Fellow for Constitutional Studies, and Carrie Sautner, VP of Education and Visitor Experience. Tom and Carrie, thank you very much. Today's lecture is underwritten by the Richard Newman Campen Chautauqua Impressions Fund. The Campen family has been a fixture on the grounds for over 30 years, and Richard was beloved for his books on local architecture and points of travel. His work, Chautauqua Impressions, was available in the bookstore following its 1984 publication and sold out 3 printings to cement its role as a true local treasure. Please join me in thanking the Campen family and all of you for your continued support of Chautauqua. This morning, we are very pleased to welcome Annette Gordon-Reed back to Chautauqua. Ms. Gordon-Reed serves as the Charles Warren Professor of American Legal History at Harvard Law School and a professor of history in the History Department, having formerly served as the Carol K. Forsheimer Professor at the Radcliffe Institute. A renowned law professor and scholar of American history, Ms. Gordon-Reed has taught at the New York Law School and at Rutgers, the State University of New Jersey, and served as a visiting professor of American's Queen's College, University of Oxford. In addition to her teaching, she has published 6 books, among them The Hemingses of Monticello and American Family, which won numerous awards, including both the Pulitzer Prize in History and the National Book Award for Nonfiction. Most importantly, at least to all of us here, the Hemingses of Monticello was also honored as a Chautauqua Literary and Scientific Circle selection in 2009. Her most recent book is titled Most Blessed of the Patriarchs, Thomas Jefferson and the Empire of Imagination, which was co-written with Peter S. Onuf. Ms. Gordon-Reed received her bachelor's degree from Dartmouth College and a JD from Harvard Law School. She is joined by her husband, Robert Reed, on her 3rd visit to Chautauqua. Her lecture today is titled The Supreme Court, Hamilton's Vision versus Reality. Please join me in welcoming Annette Gordon-Reed to the Chautauqua stage.
Thank you. Thank you very, very much. It's great to be back here for the 3rd time in this newly revamped amphitheater. Wonderful backstage comfort and great acoustics and everything. It's wonderful being here. The first time I was here, I talked about Jefferson. The second time I was here, I talked about Andrew Johnson. And I figured I would mix it up today to talk a little bit about Alexander Hamilton. I want to get in on all the mix and the buzz, it's not my normal subject, but he is someone who figures in our life because I'm a law professor, and we talk about the Constitution of the United States, and of course he had a hand in crafting that. And I just thought it would be a good thing to sort of think about what people originally thought, sort of take off on what he originally thought the federal judiciary was supposed to be about, and what it has come to be. It's an interesting time to be doing that. We are in a moment in American history where people are sort of looking back at the founding. We always do that, but I find that there's particular interest now in the question of what people thought they were doing and how far away we are from what they thought, and whether or not we should even be thinking about their attitudes. To what degree should their attitudes determine what we try to do today? It's interesting because the court has become such a huge part of American life in a way that I can't imagine people would have envisioned it. It was a part of a tripartite system of government, the executive branch, the legislative branch, and the judicial branch. The American colonists being from Britain, sort of culturally British, of course, took law very, very serious. We're very law-minded people, and obviously there was going to be a branch that dealt with law because it was supposed to be a country, a new republic that was supposed to be based upon law, the rule of law and not men, a government of law and not men. And so that was always going to be a part of it. But you may know the court was not where the action was in the beginning. It was the Judiciary Act 1789. It was one of the first things that they thought about when Hamilton writes in 6 essays in the Federalist Papers about the judicial branch as a way of trying to calm the fears of people who were suspicious of the new national government or the whole idea of a national government. And Federalist 78 is very well known to law professors and to others as explicating this understanding of what this new federal law system was supposed to do. And he explains the need for judicial review, he explains the need for lifetime tenure, the idea being that the people who administer the law or who interpret the law should be independent. They should feel free to make decisions based upon their understanding of what would be the best thing to do, as opposed to what was the partisan thing to do. Now, of course, the judges are picked by a party. They were thought of as parties at the time, but certainly there's a political aspect to it. They are picked by the executive branch, and certainly the thoughts and the feelings and the policies of whoever picks these people will influence the people that they choose to sit there. But the idea was that law was supposed to be separate, and interpretation of the law could be separate and might rise above politics. Hamilton talks about, describes the court as, very famously, as the least dangerous branch of government. Now, and you laugh, and you might laugh because we know what the court has become. But, well, I didn't put it like that. The court is a wonderful institution. It's the best job in the world, being a Supreme Court justice, I would imagine. But we know how powerful the court has become. But in those days, in the days before the legal realists came and told us that law was really about politics, there was thinking that it was possible for people to be guided by reason. He said what the judges offered, that the new federal judiciary, and of course the Supreme Court as the major court, that what they would be offering would be judgment and reason. He's taking off on Montesquieu, a philosopher who influenced many of members of the founding generation. The executive brings the energy. The executive is the one who executes for the government. The legislative branch represents the people. And the court, he says, brings judgment. And because the court doesn't have power, the executive has power over the military, he has the sword, and the legislative branch has money, the purse. What does the court have? The court has judgment and reason. And for that reason, he thought that he constructed the court as the least dangerous branch. Dangerous, probably his understanding being potentially harmful, because they couldn't wage war and they couldn't cut off the purse strings. But what he's not anticipating was how important law would become to Americans. I mean, it's always a part of the American psyche, but a country that has a written constitution that is contractual in nature, sort of telling people what their rights are vis-a-vis the government and the government's responsibilities, what it can and can't do, makes people think a lot about law and see themselves in terms of the makeup of law and how law influences their lives. I'm sure you know of Tocqueville's famous tour in the United States in the 1830s. This is after Hamilton's time. This is after the court has come from this institution started out with basically 6 people that rode circuit and seemed pretty, were sort of dissatisfied with what they thought was their second-rate status, that had been built into a much stronger institution when John Marshall, the first Justice Marshall, was on the bench and really brought the court into its own as a national body and as a co-equal branch of government. But by the time Tocqueville gets here in the 1830s, the United States, he finds and says, is extremely, what he calls it, law-minded people. He said every dispute in America eventually ends up in a court. And people go through their lives as if they're judges or in some sort of litigation. All their day-to-day problems are, used, people talk about things in terms of legal language. Very legalistic place. And, he ponders this and talks about the role of lawyers and the power of law in the American imagination. And certainly, that is something that has grown over time. So this idea of judges who just sort of render judgment and don't have power can't really hold in a society where every single person thinks of themselves in terms of legal rights and thinks of a written constitution that is like a contract, a form of contract. And if that is breached, what do you do? And you go back and forth in that way. And the power of the court grows over time. And certainly, with the breakdown of law with the Civil War and the reconstitution of the United States, or using that term, but the reorganization of the United States, Reconstruction, and the Civil Rights Amendments, the 14th Amendment adds to this as well, because it helps to transform the American Constitution. It expands people's rights. I mean, the idea at first was to bring black people, really a method of bringing black people into citizenship, becomes something that applies to all Americans. So you get a further sense of a law-minded people, or people who can look to law to vindicate their particular rights. And we know the story with that, even though there was this movement to bring blacks into citizenship. We understand after the end of Reconstruction, there was a backlash, and the South put forth a number of laws that were to sort of curtail black rights and sort of bring things back to the way they were ahead of time. And we really get to the point in the 20th century. It's not until the 20th century that we have what is called the Second American Revolution, where people use law to try to change American society, looking to the courts once again to bring about change. Beginning in the 1920s, a number of black lawyers, people who were Charles Hamilton Houston, who was trained at Harvard Law School and eventually becomes the dean of the Howard Law School, and other lawyers at the NAACP Legal Defense Fund, looked to the Constitution, to the 14th Amendment, and to the courts as a way of effecting change. People think about Brown versus Board of Education, as something that just sort of burst on the scene in the mid-1950s, when in fact that this was part of a process in the 20s and the 30s, people using law, using the Constitution to help transform society in the sort of steady, I should say fits and starts, but in the sort of orderly way that law proceeds. A lot of my students and I myself went to law school thinking that we wanted to change the world because we thought that law was the mechanism of doing that, the best way to do that. In some ways it is, but law is a conservative profession, and lawyers are conservative. With a little c, we go through process, we follow rules, we don't, I guess as Robespierre was a lawyer. He kind of went off the rails a bit from that. But by the most part, we're not bomb throwers, and we proceed through law. And so we have this process, again, started in the 20th century that progresses 20s, 30s, 40s, 50s with black lawyers and white lawyers as their allies who try to take this Constitution that has been transformed from the Constitution that that Hamilton would have worked on, and certainly antithetical to a lot of the things that he would have thought. We will get to that in a moment. To sort of change things as a mechanism of reform. And we began to think, Americans began to think of the Supreme Court and the federal judiciary, this branch that Alexander Hamilton called the least dangerous branch, as a tool for a form of revolution. Now, some people found that dangerous, as a dangerous conception. Others found it quite liberating. And we began to look to the court for answers. Now, there's a difficulty with that, is that America is supposed to be, and people remind us, it's a democracy, it's a democratic republic. But we think that majority rule means something. And the unfortunate fact was that many Americans did not care very much for what was going on in the courts. In fact, you had to resort to the courts to make these kinds of changes because it was very difficult for the political system, the legislative system, particularly in the South and in other places as well, to absorb the changes or to make the changes that people were trying to fight for as they tried to transform the United States of America and make it a place where equality was important for all Americans. So we became used to, I think, using the court to achieve political ends. It's not surprising. As I said, we're all legal realists now, if not critical legal studies people, at least legal realists who believe that politics is an element, is definitely a part of law. It's a political process. But what I mean is that people did sort of lost confidence or understood that it was very, very difficult to make the kinds of changes that they wanted to make legislatively. And we relied on courts to do those kinds of things in the area of civil rights and justice. Any kind of groups who felt disfranchised, people who felt that they were marginalized, didn't feel, and probably rightly so, that they could rely on legislators to get the job done. I know the people who trained me at Harvard Law School, many of them were clerks for some of these judges, Justice Warren and Frankfurter and others, Brennan, and they had enormous faith in the federal system, the federal judicial system, and courts to resolve problems. I think they looked down on state court judges in some ways. Federalism, the idea that states could be doing things that were creative and forward thinking was not really in their mind. They were very, very much into the federal judiciary, the elites of the profession, and had enormous faith in that because of what had happened in the Warrens Court. And I'm sure many of you know about, say the Warren Court, you think of an era of liberal jurisprudence, a place where the court is being activist. Now, I should say that at various points in American history, courts have been activist. And it's not just the quote-unquote liberals or left who have been activists, going through periods of activism. Activism depends, I think a lot of it, the designation depends on whether or not you like the decisions that people are making. If you don't like them, you're saying the people are stepping outside of the boundaries of what the court should be doing, and you're becoming dangerous. You're doing stuff you shouldn't be doing. If you like it, then you're pursuing justice and so forth, one way or another, or redressing a balance. But certainly the Warren Court is known for that people would sort of cite that as an activist court because it was a court in which a lot of very, very important rights were given to people. Some were actually, in some ways, actually quite conservative, but people don't focus on cases like Terry v. Ohio that establishes stop and frisk, which has been was an incredible boon to law enforcement. and has still a problematic issue, or sort of a controversial moment now, controversial doctrine today. But for the most part, you think of expansion of welfare rights, expansion of criminal justice, criminal procedure in other areas, voting rights, all those kinds of things you think of as the Warren Court supporting it in an activist time. And my professors, as I said, thought that this was sort of the heyday of the federal courts and federal court jurisprudence. Again, very different than if you rewind the tape back to the 18th century, thinking of what a court and the federal courts are going to be able to do. But obviously a transformed country, a much more complicated country, and I said with the addition of the 13th, 14th, and 15th Amendment, a real change in focus in the court. I should also add, in this process, not just civil rights, the New Deal, Franklin Roosevelt, and the notion of economic justice helps transform people's understandings about what the court could do, and giving hopes for the court as sort of a refuge for people who felt that they could not rely on legislators or the executive to do what needed to be done in order to help bring about fairness in their lives. Then something happened, and the 80s happened, and Chief Justice Burger happened, and Chief Justice Rehnquist happened after that. And the federal courts and the Supreme Court shift the understanding about what they're doing, and this is sort of the reaction the reaction to the Warren Court and what had been seen as two activist courts. People say we should sort of rein things in and bring things back to where they were before. Actually, not just back before Warren, we're still in the process of bringing things back before FDR. I mean, what we're in now is a period of sort of retrenchment from everything from the 30s up until the time that Burger and Rehnquist were Chief Justices. And so the court, again, becomes an active, actually more visibly, an active part of the political process. This notion of just rendering judgments or reason is pretty much out the window. People understand in a way that they may never have, or certainly becomes a real part of people's political calculations, what is going on with the court. So when you have a presidential election, we're at a point now where people really become single issue in the way they think about how they vote. What they're thinking of is not just the policies that the executive is going to enact because of, through the powers of the executive. What they're really thinking about is who is this person going to appoint to be the Supreme Court, to appoint on the Supreme Court. That is a real, almost single issue for people. And it's sort of interesting to think about, that it's come to this point that we've given this kind of power to 9 people in a democratic republic. Everything turns, or so much turns, on people's understanding of what the court is going to be doing. Now, I go back and forth on this question because, as I said, I was trained by people who were Supreme Court clerks themselves, and some of them go off and become federal judges, and they come back or whatever, and so they're very much into this system, and that was my prejudice as well, to think about the federal judiciary, this branch that was not supposed to be dangerous, but understanding that it is in fact is a sort of a seat for a lot of activism, a lot of ways to transform society. My default position is to sort of say, yeah, these are the people who should be making decisions. That is an elitist position, I understand. It is a Hamiltonian position, I would say, because I think he would clearly, from his life and other writings, understood or believed that elites, the people who had been trained, he mistrusted the people, that much more so than that other person I write about, Jefferson, who had an enormous amount of faith in the people, a touching faith in the people, and I think in some ways a naive faith in the wisdom of the people. But here we are. I mean, what can you do in a society? You know, what's the alternative to that? Relying on the court in this fashion. If they are the supreme arbiters of law, if they are, in the system that we have, this document that we look at as almost sort of a secular sacred text, the Constitution, they're the ones who interpret it, it's sort of hard to see a way out of that other than people, citizens taking it upon themselves to become more active. I think one of the things that happened, I would say in the 60s and the 70s, one of the things that this has gotten us used to is sort of thinking that these people, this group of people, can save us. You know, we're entrusting them with our lives, entrusting them with the future, and you know, we'll campaign and we'll go and we'll vote for the person who will pick, we think, the right folks. But all along the line, there's politics to be done. There are things to be done all along the lines besides relying, you know, that don't require relying just upon judges, whether it's the Supreme Court or federal judges, at all levels. The original idea, to take off, moving away from Hamilton a bit, and the original idea that Jefferson had, and he had a very different understanding about the judiciary. He thought that, and many people thought at the time, that all three branches of government had the power to declare what was constitutional and not constitutional. That's a difficult thing to work in operation. There has to be a final arbiter of this, and the Constitution, you know, makes pretty clear to me that it's supposed to be the Supreme Court. But along with that is this idea that democracy requires a robust participation by citizens, that it is not a good thing to rely just upon representatives certainly not judges or a president on his or her own, maybe one day her, but his own, to make all the decisions. And the thinking was that at all levels, people would be involved in their local governments, they would be involved in the state government, and they would be involved in the national government. And if people were vigilant, not just about voting, but about talking to one another, about meeting and discussing things and paying attention and participating, then you wouldn't have to rely on courts or a court or 9 people to make all of the decisions. I, as I said, am ambivalent about this. I am, I trust people. I believe there should be participation, but as a member of a minority group, minority in terms of numbers, as an African American person, women are not a minority, but we have been marginalized throughout history. And so I'm not so gung-ho just about majorities, that majorities are always going to make the right decisions, but I understand that that's the principle upon which we live. And certainly the Constitution is there to protect minority rights, to provide a check on this kind of thing and protect minority rights. So I'm straddled the fence between faith in elites, that education makes a difference, that experiences make a difference, people who have traveled, people who read widely, people who see other parts of the world and try to see different points of view. I tend to believe that those people might make better decisions, but that's not always the case. So I'm at a loss at this point, other than to think that to have faith that participation, if people really do try to talk to one another and have a faith in the political system that we are all part of this, that will make things better. I don't think this motion, I am certain that this idea of relying just on the Supreme Court to answer questions the Supreme Court to do every single thing is the way to go, because we create all kinds of problems with decisions that don't have seeming the legitimacy of decisions that have come through the legislature when the court makes pronouncements. But I'm happy when they make the pronouncements that I want them to make. So again, I'm torn here about what it is to do, the sort of opportunism of getting that decision in, but on the other hand, without having worked, without having doing the work of building a party, the work of communing with people or convincing people or persuading people. But that's where we are. And people ask me now, because we are sort of in unprecedented times, I mean, whatever your political views, one way or another, I think we all have to concede that this is a different time in America, and that's what a number of people voted for, something that's very, very different. And a president who is very, very different, a style of dealing that's very, very different. And we'll have to see how our system adjusts to this, the ways in which it adjusts to it. Right now, the courts have challenged the executive branch. They have supported the executive branch where they think that he is right. It's right about various things. So we'll have to see where this goes. I'm confident. I try to be hopeful about these kinds of things, that the system that was put in place will sort things out one way or another. And the courts that have been sort of progressive in some ways, not progressive in other ways, but now we're sort of presented with a choice about in looking at a system that has become, in a presidency that's very different than we've encountered before, of which way to go. And it's great for law professors. It's great for historians as well, too, as a matter of fact, for both sides of it. I mean, I get calls all the time to talk about various things from the legal standpoint and from a historical standpoint. But this is a moment now that we've never really been in. And because of technology, too, has shaped all of this as well. This is something else that I think obviously has contributed to all of this. What role do citizens have in a situation like this, in a moment like this? But it's certainly not giving things over, I think, to a court, giving things over to the Supreme Court alone. This is something that's going to require all of us to step up and make our feelings known, one way or another, left or right, Democratic or Republican. This is a time, I think, for citizen engagement and not relying just on courts or thinking, who's going to be on the Supreme Court. That's very, very important. But at the local level, at the state level, the legislative branch, the executive branch, people now are calling their Congress people. I have friends who call, Congress. I mean, I'm in New York, so it would be preaching pretty much to the converted in lots of ways. But on both sides, people are active, and I think that's the hopeful sign here, is that people are sort of awakening to the fact that it really is citizens, everyday citizens, who are going to make a difference here, and by making their voices heard. I don't really know how Hamilton would have thought about that part of it. Well, I guess I kind of do know. As I said, he was a bit wary of the people as a group. I could go back to Jefferson, a more a subject that I know better, and I think he might be very interested in what's going on now, would think that citizens calling and participating would be a good thing, as opposed, and certainly not relying on courts to sort everything out. That would not have been his answer to it. But in the end, we have a situation where we can see what the American experiment is really about, to test it and to see if it can last, see how it's going to last, see what we can do to transform the polity in ways that will be good for the future. That's the way I like to think about it. I have a number of friends, and I confess that I'm on one particular side of the aisle, and most of my friends are concerned and think that this is the end of the world. I don't think so. I don't think that that's it. I don't. I think that there's a chance for us to come out of this with all three branches of the government stronger as we sort of renew values. And it makes us think about what our values really, really are and how, to what extent does the system that we created in 1789, is it working for us in ways? If it's not, what can we do about that? How do we change that? I think the issue has really been joined. And it is a time for people to actually step up to the plate. And it looks like people are. I don't know about your communities. But as I said, among the people that I know, there's a renewed sense of activism, a renewed sense that we just can't rely upon other people to make decisions for us and to save the day. The court is not going to ride in and save the day. We have to make our feelings known, because I also think that it's pretty clear that the court pays attention to public opinion. I mean, they may not say, well, they're certainly not going to say it in their opinions or admit that in their opinions, but if people on either side are out, making their feelings known, I mean, the courts respond to that. They're in black robes, but they're pretty political themselves. They understand politics, and they also understand their role. And I think the best thing that Hamilton says, or the thing that I agree with the most, even though we can talk about this in the discussion, the importance of the independence of the judiciary is critical. I mean, I know people don't like the idea of lifetime tenure, and you don't like it when one of the justices that is rendering decisions that you don't care for, you'd say, why doesn't that person retire? It'd be great if that person could be term limited out of it. But I think it's so critical in a country that is diverse, and as this country is, to have people on the court who don't have to think about, what others feel about what they're doing, who can migrate, who can change their minds, who can think about the subject matter in ways that they wouldn't, I should say, if they were under the gun of certainly an election or having to rely upon a shortened time horizon. I think that for whatever problems we have with that, I think the benefits certainly outweigh the burdens. And I think it's something very, very much needed for people to be able to make decisions that they think are tough. John Roberts made a very, very tough decision with the ACA. And he did it in ways that people didn't anticipate. But I think that that's an instance of someone recognizing at this moment, whatever his personal predilections may have been, that was not the time to kill off the ACA, and that was not the way to do it. The way to do it, if people want to do it, is, I guess, the way it's going to be done now. But it wasn't for him to do that at that time period. And you can have that kind of restraint. And people were very, very upset with him about that, because people who take this idea that the court is overtly political, he was put there to do this particular thing, one among many things that he should have done it, but there was restraint. And he was able to do that because he has lifetime tenure. And he was able to do that because he had the luxury of actually applying judgment and applying reason to a decision that could have been completely political. So, I alternate. I'm an optimist by nature, I think. I alternate between pessimism and optimism, but with a much more of a tilt towards being optimistic. And I'm optimistic now, I will say, because I do think that people are more engaged on both sides. And if we could find some way to talk to each other in a civil fashion, I think minds could be changed on both sides. I think most people want the same things for their families, for their loved ones, but we don't know how to talk to one another in a frank and in a civil way. We don't know enough how to do that. I don't know that the internet helps. I think it hurts in a lot of ways. I mean, I have found a number of people you find your compatriots, you find people that you agree with, and sometimes shut out the folks that you don't agree with. If we could find some way to talk to each other civilly across the aisles, we could take some of this back from the elites. We could take a lot of this back from judges relying upon judges to answer things. And we can we could do things in the way that I think was intended for democracy, a democratic republic, and that is for people to make decisions among themselves, understanding the humanity of one another, recognizing that and respecting it, and trying to make the best community that we can. So with that, I think I would like to take your questions.
So as we enter into our Q&A, I would remind those who are heading off to other program to be as respectful as possible for those of us who are going to be in a discussion with Annette here over the next half hour. Also a reminder that you can ask questions via Twitter using the hashtag CHQ2017. You talked about the faith that you do have, that civic participation, that talking to one another and not relying on the court necessarily is very much possible, and that you indeed have seen there are hopeful signs that people are awakening. But you also acknowledge it's a moment in many ways that we've never been in. How can we look to our history, and where within our history can we look to enable us as citizens to affect change?
Well, I think the civil rights movement was I could say, one of the finer moments in American history, where people who, there's some very, very long-standing, long-established prejudices that existed within the population, from slavery, from the legacies of slavery, of all of that. People really did come together, and the people who were leaders were very steadfast in putting sort of having a moral center about the morality of the cause. They did a very, very good job of making that shine through, and that, I think, encouraged people from all different faiths, all different races, to want to be a part of it. I think I think it was tremendously important to have King as a leader, or the notion of nonviolence, the notion of loving your neighbor, which is not an easy thing to do. Loving your enemy is not an easy thing to do. But to just say that, to think about, to make people open to the idea that just because you're antagonistic to something, that you have different ideas, doesn't mean that you have to be an enemy. One of the worst things that I read a couple of days ago, when somebody was talking about John McCain, and they were basically wishing him death, saying, he is my enemy, and I wish death on my enemy. Well, you just think, who says that? Who has that? Of course, the internet can help you say anything, but that kind of feeling that if a person is opposed to you, that you're in sort of mortal combat with them, if that could be diffused in some way, and the only way to do that is by example, is by people, and there are leaders, there are people who are trying, individual communities who are trying to reach across the aisle, to reach across differences and do that. But I think that's the civil rights movement, I think, is a lesson, is an object lesson for people about how to conduct a movement, how to persuade people.
With the lifespan gains of recent decades, did the founders expect judges to sit for 40-plus years? And what are your thoughts on this development?
Well, the lifespan gains, I should say, to be technical. The lifespan gains are made in youth. If you got past a certain point in those days, you lived a pretty long time. I mean, Jefferson is 83, you know, Adams is older as well. You know, they probably didn't think that, obviously didn't know that there would be ways to keep people alive for a very long time, but I think they're pretty active folks. I mean, Ginsburg comes to the law school, and she is all there. I mean, you know, I mean, she's all there. There's no, she's more there than people who might be, you know, 40 years younger than she. So, no, they didn't expect it, but they also probably did not expect that people are in better shape than they were in those days because of medicine and diet and so forth. So I understand the nature of the question. The problem is, how long is too long? Do people want to go on with it? But I still think that the benefit of not having to look over your shoulder, not having a sense of a timeline, I think has been really important to the way, you know, you look at justices and they have their philosophy has changed, and you learn a lot as you grow older. I mean, the idea is you're supposed to, I mean, we worship youth in America. Other countries respect the wisdom of people who are older. So, you know, I don't understand. I think that as long as the person is mentally, you know, fit, and none of the people that I've, you know, encountered from the people that I've met on the court or know about on the court, they're there, and they've seen a lot, and I think that that's worthwhile. That's something that's important.
This person asks, do you have examples of good and productive forms of civic engagement around significant policy issues that you can point to as examples?
Well, certainly at small levels, on a smaller scale, local level, I think New York City does community work very, very well. People who organize around homelessness, people who've organized around delivery of mental health services. It's a smaller scale things, I think, are better. Churches, communities who, you know, feed the homeless, who, you know, find housing for people. I mean, the church I belong to in New York is very active in those kinds of things. Those are the things that I know. People at a smaller level who are making a difference in their own particular communities. I think that's what it's going to be. Bigger scale, large scale things are quite important, but community things have been what I've seen the most and have been effective.
This person asks, how has activism in lower courts influenced the Supreme Court?
Well, it determines, well, what cases they take, what things they feel they have to fix. Sometimes they get things from lower courts and they feel that they have to smack it down. Other times they let it stand. But it influences the court. I mean, the court looks at all these things and decides, you know, of the panoply of cases that they can take, they'll decide whether or not what someone has done below is too much, if they've gone too far. And they'll take it up and make a decision to correct it or let it stand.
I want to read this question as it's written. Can you address the fact that the cry for civil discourse comes from the left only?
Well, yeah. That's an issue, but you got to do what you got to do. You can be the voice crying in the wilderness and hope that somebody hears it and comes along. But I do think, people in this country understand that we're sort of at a crossroads in a lot of ways. A lot of people are hurting. The opioid crisis the crisis of employment. What are we going to do with all the young people? What are they going to be doing? I have a feeling that the other side, if you want to call it that, it's a lot of bluster at one level, I think. If we could ever get to the point of the kind of discourse that I talked about, it'll be small people. I think it's small numbers of people might be peeled off. I think if we changed the way we approach people in some ways. I mean, there's been a lot of talk now about what people consider to be the condescension of people who are considered liberal or moderate, center, however you want to describe it. Changing the way you approach people. I don't think you can't make other people do what you want them to do, right? You can't force them to be civil. But the only thing you could do is to let your light shine, let yourself be the example to people, and hope that something cracks. As I said, with the civil rights movement. I mean, I grew up in Texas, and I grew up in East Texas, a very, very tough place. And it is not racially okay now, but the atmosphere there is so different from when I grew up. I mean, I see people older people in particular. I remember being in a library once, and I heard this couple, these four people, and they were trying to convince another guy to go on some retreat that they had gone on. And one couple was black and one couple is white. And I know those people did not grow up going to retreats together, or going to, or associated with each other. And here they were, just like as normal as day, talking about, well, yeah, you should really go because we were there last year and this, that, and the other. And it's a huge change that would have been impossible to think of when I was growing up. And I don't know how that happened. I don't know what alchemy that was that changed things, but it had to have been the examples of others, sort of persevering, one step at a time. It's going to take time, and that's the thing that makes us impatient. But you can't change the other side. You just have to keep, I think, pressing with your claim in good faith, and recognizing the humanity in other people. And sometimes that peels some folks off. It won't get everybody, but I think some people respond to it.
What you've just pointed to as well, I'm thinking of a conversation I had just yesterday with a couple folks looking at activism at a local level, where some of that civil discourse and alliances can happen, that perhaps a call for civility at a national level is more politics than anything else, and yet change can happen when it's affecting a smaller community.
Yeah, well, some people think, it is civility. Some people call it pearl clutching, that civility is just it's a fake way to stop people from voicing strong opinions. But there are ways to express some really, really tough and hard opinions without being, wishing death upon someone, or being, totally snarky or whatever. I mean, you can have hard discussions in a civil way. And I just think it's the nature of media. First it was cable news, and then it was, social, sort of anonymous social discourse where people can say things or put things out there that they would never say face-to-face to people. Smaller communities, the smaller venues where people are talking, it's hard to say mean things to people when you're looking at them. I mean, you have to be really, unless you're angry at them. But I mean, for no reason. It's hard to really be nasty, but it's easy to do it on the internet. And I think people have gotten used to that. But I think that taking place in smaller community groups, that's a better way to do it. That's going to be what makes the change.
Are you hopeful about civility in online discourse?
No. I mean, you know, what is it, the old joke, you know, when you're on the internet, nobody knows you're a dog. It could be anybody. I mean, I don't, anonymity is good in the sense that it allows people who might feel that they will be persecuted at their jobs, for example, for saying things or expressing opinions. So you need to, Publius, I started off talking about the Federalist 78. Well, he's doing that, Hamilton is writing as Publius. It's not Alexander Hamilton or James Madison or John Jay. I mean, they're there anonymously writing. Everybody kind of knew who they were, but there's a space for that. But I think the downside is that it encourages people to be pretty nasty. So I have to say I'm not very hopeful about that side of it. I think it's going to have to be people in face-to-face venues, and it's going to have to be smaller venues and community people, changing people. Like the folks that I discussed earlier, the couple that I was talking about, I mean, this is a result of stuff that happened in their community. Probably church-based, a number of sort of mixed race churches, evangelical spaces where people, strangely enough, actually meet in ways that maybe people in established churches in the North don't. But that is certainly more of a thing in the South. Those kinds of interracial, connections through religion. But that's a small thing. That's real face-to-face kind of stuff. That's, I think, probably effectuated that change more than anybody preaching to them or something coming from the national level.
A few questions from Twitter. Can justices separate their decisions from their religious and personal prejudices?
They can, but they don't often. I don't want to say they don't often. I would say they often do not. I don't think that there's any question that Justice Scalia, being Catholic, the fact that he was Catholic, definitely influenced his judicial philosophy, some of the decisions that he made. But you can. I mean, you can definitely do that. I mean, there are all kinds of situations. As a professor, I know I have students who supported one candidate over the other, and I try very much. I don't make my classroom a place where they feel uncomfortable because of my using my position to make my feelings known about that. And I think judges can do that. You can be against abortion, or you should be able to be against abortion, be a judge and understand what the law is. And, the purposes of the law, and not impose your will on a particular case. Now, the tough question, as a law professor, I have to do this. The tough question is, what about other issues, moral, quote-unquote, moral religious issues? There were a number of people who were anti-slavery, and for religious reasons. How would I feel about them using their religious views to render a decision in that question? You can say it's different. Other people say it's not different. That's why many of the people who are who are anti-abortion look to Dred Scott, the Supreme Court case Dred Scott, as a sort of model of bad jurisprudence, and they sort of link Roe v. Wade to that. So it's a tough question, but I don't think that there's any doubt in my mind that it's possible for a person to have religious views and not impose those views through the court.
This person writes on Twitter, lots of chatter about reversing historic decisions. Do you think the court could take us backward? Would it be going backward?
Can the court take us backwards? Oh, yeah. Yes, it could definitely take us backwards. I think they want to go back to the pre-New Deal jurisprudence, the sort of heyday, 19th century heyday of freedom of contract notions. Yeah, it could take us back, take us forward, or take us back. They have the power to do that. Stare decisis basically is an important doctrine, the idea that you're not supposed to throw things out too quickly. You're supposed to, abide by precedent. it's a thing, but it's certainly something that can be overcome over time. And I think that I think that there is a lot of support for that among people, among legal scholars and among the people, that the New Deal represented a transformation of government, the rise of the administrative state, which people said, and delegation, that is not something, delegating these rules and so forth to people, that was never supposed to be in the Constitution. And I think you're seeing a movement on the part of the court to go back to the pre-1930s era. So yeah, we could go back, and to me that would be going backwards, but to other people would say, you just you're resetting the clock. This is where it should have been. They see the 30s and the 40s, labor law, some of those things as aberrations. And what you were doing is, they call it, the phrase they use is the Constitution in exile. That the Constitution has been in exile for a time, and what should happen is that it should be brought back. So yeah, so for some people it will be taking it back, and that's a bad thing, being unprogressive. To other people, it's a restoration. It's a restoration to what was there and what should be.
This person writes, we've seen an upsurge in street demonstrations trying to directly influence Supreme Court decisions. Do you view this as a dangerous shift from more orderly court processes?
I think it's okay for people to be in the streets. If it's, not non-violently in the streets, but if this is the way to make your feelings known, as I said before, the court doesn't want to appear overtly political, but I think it's worth letting people know what people in the country are thinking. Certainly, we can do that legislatively. The court usually, very often, will say, a number of states have changed their laws, and in this particular direction, and so we're going to continue going in that particular direction. But that comes from, watching the legislature, and legislators are people who have been obviously voted in by the people. So in that sense, you're getting a sense of what the people want. But I think that's one way to do it. But I also think that being in the streets on demonstrations is a way to remind people that, that's exercising your First Amendment rights, that these sorts of things are important to them. They're not going to be, oh my God, there are 30,000 people out there, I'm going to vote this way. But it might be a reminder. It might make them consider other points of view. So I think that there are lots of ways to participate in an American democracy: voting, in legislators, demonstrating, writing op-eds, doing all those kinds of things. That's just one tool in the toolkit.
Did Hamilton envision the court's sharp divisions, or was compromise envisioned?
He envisioned the sharp. I think he thought, or sort of assumed, that there would be certain kinds of people who would be on the court, and that they might have more consensus because they are a certain type of person. He obviously could not have envisioned the plurality, the sort of pluralistic nature of American society, all the kinds of different people, constituents who would be participating. The court is not all that diverse, obviously, but I think he thought that they would be more like-minded than not, and that they would, because I think he believed, and judging from what he's saying there, he understands that law is political, but the people at that time thought about law in a very, very different way. It was not a science, but it was definitely something out there that could be discerned and that was real, and we don't think of it like that. I mean, we think of it as much more, constructions, political. I think he thought that a group of elite, honorable, he would say men, whatever, and they would be men, could come to a judgment, a reasoned judgment about things, and not as contentious as it would be, and if they're paying attention to or have to have to pay attention to the sort of wide array of people that the present court has to think about.
Would TV or publishing Supreme Court discussions help the public to understand civil discourse?
Ooh, I'm a conservative on that one. I don't think they should be televised. No, I think no. I don't want it televised because I think it will change the nature of the court. They would be Judge Ito, from the OJ. No, that's not fair. Judge Ito is a perfectly fine person. I think it would change their behavior. And I know people say this is sort of mystifying, these people up in their robes and nobody knows what they're doing and they're deliberating and all. It would be a theater, and I'm so sick of everything in America being a show. She says, at a show.
Where are the checks and balances for federal judges?
The checks and balances, the upper level, don't want to get reversed. That's really it. A federal district judge is really, really powerful because they don't, the appellate judges, they have to worry about splits in circuits and maybe the Supreme Court will come in, but federal district judge at that level, they have a lot of power. The only checks are the possibility of being overturned. The checks are that other districts, other jurisdictions will come up with laws that are conflicting and, they will suffer in comparison. They have a lot of power, I will admit. They do have a lot of power. So being overturned is the main thing that they have to think about. That's why you really want to be careful about who sits on the bench and who's given this great honor and privilege. But they do, I will admit they have a lot of power.
If democracy requires robust participation of citizens, should we have a federal requirement to teach civics in well-funded public schools?
Yes. No, yes. It's a lot of people don't really know what this is all about, and it's not their fault because they haven't learned and haven't been taught what it's all about. So yeah, I think civics, I think so. Kids, being a citizen, it's a big responsibility, and when people don't exercise that responsibility in a responsible manner, we all suffer for this. And so I think doing that would impress upon people the importance of it. I think people thought it was corny, right? Or using an old phrase, it was sort of old-fashioned to do that, but it's critical. I think it's absolutely critical that it should be a part of a curriculum. For high school students should know the three branches of government, what they do, what their responsibilities are, what the responsibilities of citizens are. Yeah, I would be in favor of that.
In defending decisions, does the court quote from the Federalist Papers to support original intent?
Well, it's sort of interesting. The Federalist Papers, there's a tendency for scholars to talk about the Federalist Papers as if they had some huge effect at the time, and they didn't. They were not published. They were published in its entirety only in a couple of places. It's not like everybody was running around reading the Federalist Papers and trying to decide. I think they try to do that. They cite that to try to discern what original intent was. That's a difficult thing because Jack Rakoff, who's written a book called Original Meanings many years ago, a very important book, and others have talked about the fact that they didn't know at the time what they meant. Washington, he's in his cabinet. He writes to people 3 years after it's ratified and says, so what do we mean? Well, what did this mean? Or what was it? at the moment, they argued about what the intent was. But certainly citing the Federalists and, those kinds of things make you seem sort of learned, and as if you have some special, pipeline to what they're doing here. But I don't think that I have questions about its utility.
Last question.
Other than a historical thing. It's important to know these things, but it's not necessarily key for you to be bound by them. What somebody's saying in 1788 and understanding about judges, when, as I've tried to say here, the Supreme Court, the whole understanding about the court has evolved over time. I mean, we had a civil war. We totally redid all of this stuff. So it's useful to know these things for historical purposes, to understand where we came from, but to be bound by it, I don't think that that's for me, that's not the way to go.
Last question. What does failure of the American experiment look like?
Ooh. Wow, that's pretty scary. Dystopian moment here. It looks like a separate country, different regions off on their own, doing various things. Suspicion about one another. Not a pretty sight. The United States is a huge country, and the regions are all so different. And we really do depend upon each other. I mean, strangely enough, the red states depend a lot on the blue states to subsidize them, and they don't seem to believe that. But it doesn't look pretty. I could see us easily, drifting into separate countries. And once you do that, then you are ripe for foreign. I mean, the whole purpose. Well, not the whole purpose, but one of the purposes of having a union that went from sea to shining sea was to keep us out of world balance of power politics, so that you didn't have other countries coming into to different parts and making common cause with this region versus that region. The idea was to take us out of all of that. If we fail and split up and go to all these different places, then you have that again. You have other people, other places picking us off one way or another. And that's a nightmare scenario. And I don't foresee a failure of the experiment. I'm trying to be optimistic here, but it would not look good.
That's civil engagement and discourse.
Exactly. Yeah.
Ladies and gentlemen, please thank Annette Gordon-Reed.